Okay, thank you. I'm Don Kerwin. I'm with the Center for Migration Studies of New York, which is where you are right now. And we're delighted to have with us today Juan Osuna, who recently left a superb period of government service, stretching back almost 17 years in 4 administrations, believe it or not. A quick introduction. Juan has served as, when I first met him, as a respected legal publisher, writer, editor. Then he became a member of the Board of Immigration Appeals. From there, he became chairman of the Board of Immigration Appeals, then Deputy Assistant Attorney General in the Department of Justice, Office of Immigration Litigation, Associate Deputy Attorney General working on immigration policy and other issues, Acting Director of the Executive Office for Immigration Review, which, as you all know, oversees the immigration court system and the Board of Immigration Appeals, and since May 2011, the Director of the Executive Office for Immigration Review. Those are his kind of professional accomplishments, but I just wanted to say a few words about him. This is an extraordinarily competent public servant, devoted, accessible, fair, even-keeled, exactly the kind of person that you want in the types of positions that he's had. And I'm very sorry, actually, that he's not going to be in them anymore. But I understand kind of his decision to step down at the Department of Justice. Today's format is going to be as follows. I'm going to ask Juan a few questions, maybe 5 to 10 questions. We're going to be fairly informal here. And we'll talk for 30 minutes or so. And then we'll open it up to questions from you for the remainder of the time. And kind of would ask you to keep not to speechify so much, to actually ask questions. I certainly have a lot of questions, and we'll have some follow-up questions too, but there'll be plenty of time for that. So, Juan, I wanted to thank you for being here, first of all.
Thank you, Don.
Yeah. I wanted to start with a couple of broad questions about your time in government and your thoughts on the future, and then I wanted to get into more specific issues related to the immigration court system and what you see as its future and kind of how it ought to operate. And let's start with the Obama administration. First it had broad immigration goals and priorities, ranging from comprehensive reform to passage of the DREAM Act, and then more narrow regulatory and administrative priorities as well. Looking back, I wonder if you could talk about what the priorities were, large and small, and any advice really that I guess kind of the accomplishments as well, and any advice you'd give to the next pro-immigrant administration in terms of how it should proceed kind of in furtherance of their priorities.
Thanks, Don, and good morning, everybody, and thank you for being here. And I have known, just before we get into the questions, I have known Don for a long time as well, and I've admired and respected his work, and as well as the work that CMS is doing now. So it's a real pleasure to be here with you. We've known each other for a long time, and have done some great and exciting work together. And it's always interesting to me how some of the things that we saw 20 years ago, have changed, and others have really kind of have not. And a lot of the issues that we dealt with back then are still very relevant in maybe in slightly different permutations. And then we'll talk a little bit about that. But it is a real pleasure to be here with you and with all of you. I guess that I will start with. There's no question that then when the Obama administration came in and many of us went over to work with leadership on immigration issues, that there was really one issue, and that was comprehensive immigration reform. That was really what the president at that time had campaigned on, what he talked about, what the focus was, and it was a real focus from the beginning of the administration in 2009. And that was certainly the right call. I mean, I think that it is always amazing to me, and again, going back so many years, how there's wide consensus that the system is in need of reform, that there's everybody agrees the system is broken. How many times have we heard that? Not just recently, but we've heard that 10 years ago, even 15 years ago. The system is broken. It is in need of reform. Legal immigration, the courts, the detention system, et cetera. And it is also quite interesting and appalling, I suppose, in some ways, how difficult it has been to get that done. Even going back before the Obama administration, going back to the Bush administration, seeing the efforts of, in 2006, 2007, to get an immigration reform bill done, truly a bipartisan effort at that time. Republican and Democratic members of the high-powered members of the Senate, coming together and trying to get this done. The full weight of the Bush administration behind the reform effort, and it still failed. It still didn't get done, and that was at the time with a decent economy and things like that. I think the administration came in, the Obama administration came in, fully prepared to fight the battle and to focus on CIR, obviously it's succeeded in part. There was a Senate bill that was passed in 2013, with a pretty sizable vote, and then it stopped, and then it really didn't go anywhere in the House, and it failed. I would say that that the interesting dynamic developed, pretty quickly. Was now what? Now what do we do now that immigration reform seems to have been stalled at the beginning of the second term of the Obama administration, and the administration did pivot to some other things. I think that I would, in terms of thoughts for a new administration that had the same outlook on the need for immigration reform, I guess I would mention maybe three or four things, 3 or 4 lessons learned. Number one, CIR is critically important. There's no question about that. Comprehensive reform, legislative reform, overhauling the system is critically important, and really is the holy grail that we should all still be striving for going forward. But let's not lose sight of the smaller things that are actually doable, and that may be more doable, that may be not the biggest reform possible, but that are possibly achievable within the framework of pushing for the larger reforms. And I would mention a couple of things in that regard. Number one is the DREAM Act. The DREAM Act, we came close in 2010 to getting that done. And while hindsight is always 20/20, you sometimes wonder, if maybe that was something that was achievable. How much would a lot of people right now, how much would we value a DREAM Act that is in law right now that would have benefited, what many, even the current president, sometimes acknowledges are some of the most deserving people in immigrant communities in our society. So that would be one thing, that maybe trying to not exclude or lose sight of smaller legislative reforms that may be doable within the context of the larger one. Secondly, I think that there was some lost opportunities within the Obama administration on regulatory reform. I think that there were some regulations that were doable. Now, some of you have heard me talk about how frustrating the regulatory process is in Washington, D.C., and it is incredibly frustrating, incredibly convoluted, very hard to get federal regulations done. Having said that, I think that we left some stuff on the table, some regulations that were doable, that maybe with some additional effort could have been done, especially in the asylum realm, in the way that the standards for asylum. Let me give you one example on that. In 2009, the Supreme Court issued a decision called Negussi v. Holder, which mandated that the executive branch come up with a policy for people that had been forced to persecute others or had been persecuted others, and whether there was a duress exception to that, whether they had been forced, whether if they had been forced to persecute others, they may still be eligible for some sort of asylum relief. This was a policy from 2009 that the administration made. We're going to do this by regulation. Regulations were never issued on that, and that was a small but important piece of legal, of jurisprudence, asylum jurisprudence that could have been possible through regulatory effort. Other asylum regulations were also doable. So I do think that while it is very hard to get regulations done, I think that we lost a little bit of sight while we were focusing on the large legislative efforts that the regulatory front could have been something that that was doable. And then maybe the third broad lesson that I would impart is, in part because of the diffuse nature of the executive branch when it comes to immigration policy. You know, you have different agencies, a lot of different agencies doing different things in different departments as a result of the Homeland Security Act, frankly, in 2003 when old INS was broken up and 3 different bureaus were created at DHS. You have the DOJ's role, you have the State Department's role. It's gotten very, very hard to do immigration policy in the executive branch. Very, very hard to coordinate the various agencies. We were talking earlier, as DHS has matured over the last 10, 12 years and longer, the different agencies at DHS have really kind of become real balkanized and have their own their own agendas, their own missions, and that's fine. But some of that shared information, nuanced information that you had before has been lost, and coordination on policy becomes extremely difficult. Whether it's regulatory policy or other kind of policy, it becomes very difficult. So I think that it would be worthwhile to think about some sort of coordinating effort at a very high level, at the White House level, really some sort of immigration and refugee directorate or something like that, to drive policy. And while the different agencies have their roles and their views, and they're important that their different views be presented, at the end of the day, if you're going to drive policy in a particular direction, the only time that I really saw progress on that in a significant way was when the White House was involved in a very aggressive way. And I do think that because of the different equities, the different agencies involved, it is worth thinking about some sort of immigration and refugee directorate that would drive policy in a particular direction. So those are kind of 3 broad lessons that I think I would take. But really, maybe the encapsulating one, I was just don't let the perfect be the enemy of the good. Sometimes reforms are doable that may not be, the perfect reform, but that are going to make some important advances in the law and in policy. And I think that is something that, again, looking back, maybe could have been a little different.
Yeah, I wonder if you could just give us a flavor on that, kind of how it is coordinated now, both broad policy making, but even on something as narrow as regulations.
It's an agency will propose a regulation that they believe that it's something that is, again, worthwhile, that it's necessary, it's important to clarify the law, to provide guidance to the agencies. And typically what has to happen is that it goes through internal review at the agency. Let's say if it's an EOIR regulation, it's internal review at EOIR, then it goes to internal review at DOJ, the Department of Justice. Once the department is comfortable with that, then it goes to other agencies, other departments that have equity. So in this instance, it would be the Department of Homeland Security, the Department of State, maybe the Department of Labor, depending on the issue. And then that all gets kind of kicked around, but it's really the Office of Management and Budget that is responsible for coordinating on regulatory reform, on regulatory efforts. They're the ones that really are supposed to drive the policy, but they drive the process, but not necessarily the policy at times. It's really, the policy is driven by the agencies, but more often it has been driven, in rare instances, by the White House. So it really, while the agencies should be able to work these things out amongst themselves, the reality is that because of the different interests that are out there, it has been very difficult. So it's really a combination of OMB, the White House, that are responsible for really getting regulations on the finish line, and that has been, and that's where I think, because there's so much to do, sometimes I wonder if just a dedicated, directorate or something that does immigration and refugee policy and is responsible for that is really what is necessary.
Thanks. Kind of moving to the court system, or sometimes called the removal adjudication system more broadly. I wonder, the court backlogs at this point seem overwhelming. if you could speak a little bit to the cause of the backlogs. I know there's not one cause, and kind of the ultimate solution to them.
So that was certainly that is certainly one of my biggest frustrations, I suppose, with my time at DOJ, was seeing that caseload rise and continues to rise. I think that there are various causes of it. Number one, there is no question, and there's been a lot written about this. You know, you've written about it, others have written about it, that for many, many years there really was an imbalance, and it continues to be an imbalance between the resources given to the enforcement agencies, the enforcement efforts within the executive branch, and the resources given to the adjudicatory agencies, meaning the immigration courts in this instance. That's not unique, by the way, to immigration, policy or immigration functions. I remember talking to federal judges, and they were complaining that many years ago, the FBI and other enforcement agencies would get huge amounts of resources, and everybody forgot about the courts. That somebody needed to hear these cases once, the enforcement actions were taken. But we saw this. We certainly have seen this the same way in the immigration court system. And again, a lot has been written about this. Many millions of dollars to ICE, to CBP, to the enforcement agencies, in an effort to get tough, and then not quite enough, or sometimes very little, or sometimes none, no resources to the judges who actually have to hear the cases. That dynamic was set up many years ago, and while it started to be corrected under the Obama administration and going forward, we still have a long way to go to catch up to that hole that was left by the variance there in the resources that were allocated to the removal system. So that would be the first cause, I would think. The second cause, which is more recent, was really the border situation that began in 2014. The Central American border crisis, the influx that all of you remember the summer of 2014. I tried to block it out of my mind because it was such a nightmare, but it was really a very, very difficult time. And when you look at the numbers of immigration cases coming to the immigration courts, they were already rising because of the difference in resources that I mentioned. When you get to the summer of 2014, it just goes straight up. I mean, the number of cases that were brought into the court systems as a result of that border situation was astounding. And frankly, the administration was caught unprepared. I view the 2014 border crisis as really probably the biggest policy failure with regard to immigration of the Obama administration, if I can be frank about that. The signs were there. There were warning signs about the number of families and kids coming across, and really in April, May, and June of 2014, the border just exploded and nobody was ready for it. ICE wasn't ready for it. ORR, that cared for the kids, wasn't ready for it, and certainly the immigration court system was not ready for it. Again, that had the effect of really adding a significant number of new cases to the court system. The third cause, I would suppose, is while there was a recognition that new judges and new resources needed to be added as quickly as possible, the federal hiring process is very cumbersome and very slow. And especially for immigration judges, it has been very cumbersome and very slow. And it has taken a frustratingly long period of time to get new judges into the immigration courts. It's happening slowly, and they're being added every month or every few weeks. But the process for bringing them on board, despite the efforts of a lot of people, continue to be cumbersome, slow, and take too long. So roughly those three. I think I would mention those three causes, but I do think that a lot of it has started with with that imbalance between enforcement and the adjudicatory role.
I mean, the resources are a huge issue. As I recall, over the last 25 years, the INS's budget was, I think, about $1 billion 25 years ago. And that covered benefits too, of course. And now, I think the Trump administration budget is $22 billion just just for the two enforcement agencies, which is rather extraordinary. Certainly the EOIR growth wasn't anything like that during that time. But I wanted to ask kind of another issue, which is, what, is part of this that the lack of exercise discretion by DHS officials in referring people into the court system?
Yeah, and thanks for raising that, Don, because it is, I don't want to leave the impression that it is all about resources. It really isn't. It starts with resources, don't get me wrong. I mean, you can have all the great, efficiencies and all that, but if you just don't have the bodies, you're not gonna get anywhere. So while it starts with resources, it doesn't end with resources. In my view, what would help a lot in the immigration courts, and some of this had started under the Obama administration, but not so much anymore, was that I do think that we need to look at practices that other court systems have that enhance not only due process but also efficiency. And I do think that one of the successes of sorts, although it didn't go far enough and didn't get ingrained as well as it should have, was the use of prosecutorial discretion. And what I mean by that is, if you look at other court systems, if you look at the federal court systems, prosecutors have discretion. Prosecutors have discretion on which cases they bring, which cases they litigate. They can plea bargain, they can do this and that. Those kinds of efficiency methods, efficiency aspects of court systems don't really exist in a very meaningful way in the immigration court system. Again, under the Obama administration, things began to kind of loosen up a little bit in that regard. I mean, there was some very important and I think worthwhile initiatives towards giving prosecutors, in this case ICE, but also other DHS enforcement officials, some discretion as to which cases they bring to court, which cases they choose to litigate, which cases they choose to detain. And that did have an effect. I mean, it may not seem that way because the backlog kept growing, but it actually did have an effect in some locations to actually alleviate some of the court backlogs, focus, those resources on the individuals that really we should be removing from the country, the serious criminals, national security threats, the gang members, things like that. And it did, and judges will tell you that it did actually start to have a significant effect on making sure that the limited resources of the courts and of the prosecutors, for that matter, were focused on the cases that were the most important. That is what court systems do. That is what prosecutors do in every court system in this country every single day. They exercise discretion. Discretion is something that, again, you do it not just for due process of fairness, but also for efficiency. So I do think that another aspect of getting a hold of the backlog is not just resources, but also importing some of those discretion practices, some of those best practices that other courts have that the immigration court system doesn't have. Let me give you an example. There's one that under federal rules, there are, I forget what it is, but it's a couple of dozen enforcement officials that can actually issue what's called a notice to appear, which is the actual formal notice that begins a court proceeding in immigration court. It's a formal document that charges somebody with being removable from the country and initiates the court proceedings. The regulations allow, a couple of dozen DHS types of officials to issue those types of notices to appear. To me, that's crazy because there's only one prosecutor in immigration court. That's that is the ICE attorney. In my view, that process should be consolidated so that each NTA before it's issued should go through a review process to see if it really should be filed. If it really does meet enforcement priority, if it really does meet the requirements, the legal requirements and other requirements for it to go forward in immigration court. That's an important discipline that I think other court systems have because you're giving the prosecutor control over his or her caseload that we don't have in the removal process. That I think would help efficiency, that would help make sure that cases are actually filed that should be filed and other cases are not. But those types of prosecutorial discretion mechanisms I think are disfavored now under the current administration. I do think that it was an important initiative that the Obama administration took to try to do enforcement and adjudications more intelligently, given the lack of resources throughout the system that existed and continue to exist.
So the next question is a little bit fanciful at this point, I would say, and has to do with how, if you were given carte blanche in a future administration to kind of redesign the removal adjudication system entirely, you know, how would you, and the immigration court system, of course, is central to that, how would you do it? The reason, of course, it's a little bit fanciful is that the movement now is to greater informalization, and the fact is that I think it's almost 90% of the removals now take place without court oversight, without the person removed ever seeing the inside of a court system. And the idea is to actually expand expedited removal and essentially nationalize it. But it's not just expedited removal. It's expedited, it's reinstatement, it's stipulated removals, it's administrative removals, it's on and on. So it seems to me that the trend here is to take more out of the court system and to deny due process to people, to kind of make the enforcement agency, the judge, you know, the jury and the prosecutor all combined. But if you were to create a system that really, you know, took enforcement seriously, but also took due process seriously and the rule of law seriously, and you were able to do that from scratch, what would it look like?
At least you don't ask me any challenging questions, Keith.
You can write an article for us.
Yeah, well, yeah, if I had the answer to that, then, so the short answer really is you're right, that it's a little bit of a, you know, somewhat speculative. The trend, I think, and I think you're seeing more of this with the current administration, is to try to do things without a formal court system. I think the recent news about the desires to expand expedited removal, you know, to cover a lot more people. I think it's probably Exhibit A on that. And certainly the administration has the authority to do that. You know, whether it's good policy, I think you'll get a debate on that, but certainly the authority is there to do that. I don't know, Don. I mean, this is actually quite a vexing problem. Let me just focus on one aspect of it, because I do think that that it is something that troubles me quite a bit. That again, I think came to light really over the last 3 or 4 years more than ever, which is the asylum system. I think that the asylum system in this country is in deep crisis because we have international obligations to protect refugees. Our laws are designed to try to give a fair hearing to those that fear persecution in their home countries. And right now, because of the overwhelming numbers and the lack of clarity on the law, we're failing. And I'm not just talking about the delays in the immigration courts. I'm talking about the delays in the asylum offices as well. DHS asylum offices, I forgot what the numbers are, but the backlogs there are overwhelming as well. In my view, I think that it's been about a quarter century since we put the current asylum system in place. The early 1990s was when it was done administratively, for the most part. I do think that it is time, and the time is right, to take a look at the asylum, how we handle asylum cases in this country, whether not really focus on the court system or the asylum offices, just overall how we handle refugee claims in this country, and see if we can actually do something a little bit different. See if we can actually, handle this somewhat differently. One of the debates that's ongoing, with the international colleagues is, do we do this? Are asylum claims best handled in an adversarial model, like immigration court, or in a non-adversarial model, like the asylum offices? I think. And right now we have a bifurcated system. I think we should have a real debate as to whether what do we want out of this. Maybe it does make sense to have the first cut be completely non-adversarial, completely within the asylum office system, and reserve immigration courts for something else. But my point is whether, despite, I'm not quite answering your question in terms of a redesign of the model of the system, but I do think that the asylum system in particular, because of the high stakes involved in those instances, because of the international obligations that we have, because of the novel claims that are being brought through a lot of the Central American cases and some of the other cases, is in deep need of reform and of a hard look as to how we're actually doing this in this country. And again, not to go back to one of the prior points, but we can do this partly through regulatory reform. We tried to get this done in part through regulatory reform, and we're not able to do it. But I do think that that I would take a look in particular at the refugee and asylum system and focus on that at least as a first step to try to get a handle on this crisis that we have.
What about the at least some court oversight of these summary removal, non-court, non-process removal processes that are growing?
Mm-hmm.
I mean, people might say it's impossible, but in fact that is the way that it worked prior to 1996. I mean, the courts did kind of oversee removals, even on the border, especially on the border. So it did work at one point. Is it possible to bring that back? Maybe not politically, but kind of in terms of a long-term plan or a vision.
Yes. I mean, I think the answer is yes, but not with current numbers and current resources. Obviously, even leaving the politics aside, the numbers are just so overwhelming that I don't see how it's even doable in the near future. However, as a matter of policy, as a matter of concept, I think we do have to ask the question: do we value oversight by a judge, in the majority or most or all immigration cases, certainly for people that are at least in the country, that have been in the country for a while, whether it's, maybe recent border crossers are one thing, but certainly anybody that's been in the country for more than a short period of time, do we as a country value some sort of judicial proceeding to determine whether they should be able to remain with their families or have their asylum claim heard in a meaningful way or something like that? If the answer to that is yes, then I think the answer to your question is yes, there should be court oversight over the majority of cases that come that are being that are subject to enforcement now. Again, the problem we have is it's a problem of numbers. It's just an overwhelming logistical challenge. But as a matter of policy, I think the answer to that question should be yes.
Can I just ask a quick question on the numbers? We hear the numbers reported by TRAC and other sources. Are those I'm sure they're accurate numbers, but is there duplication? What's your sense that the real number is?
Yeah, the numbers. Well, numbers are frustrating. I mean, I don't think that anybody really has good numbers. Even the government certainly does not always have the best stats around. I think TRAC does some very good basic analysis. The TRAC does good statistical tracking of the numbers that they collect. I think the analysis is sometimes not what it should be. And I maybe CMS can do this. There's a lot of missing information. Not nefarious reasons, but I think that there is just not. We still don't have a good handle. Again, partly because of the balkanization of the agencies, because of the different agencies with different roles. We still don't have good numbers, I think, on a lot of immigration, types of issues. Let me give you an example. One of the interesting numbers one of the issues that I did work on at DOJ, not really with part of the immigration course, but it was the number of people that were being prosecuted along the southwest border, criminal prosecutions for illegal entry, illegal reentry. I think the numbers on those cases are really unreliable. We don't have a good sense as to, for example, how effective criminal prosecutions for first-time illegal entries, are in deterring further illegal entries. I think that some folks would say that they're very effective, but when you really kind of dig into it, they're not great numbers, or they're not great analysis. So, I know that DHS, under the Obama administration, has really tried to enhance that policy data analysis function, and they have some very good people over there that are trying to do it. But whether it's within inside of government or outside of government, I think the numbers are still pretty tough to get your head around.
Let me just ask one more question, and then we'll turn it over to the participants here, and that is, to the extent you can talk about this, what do you think that the Trump administration and the Department of Justice plan is for the immigration court system at this point, and generally for kind of the removal adjudication system more broadly, enforcement in the United States and the court system?
Well, I think I certainly think it's no surprise that the new administration came in with a particular view of immigration. I mean, it is. I think the view of the new administration is that enforcement has been lax in the past. That we need to get back to a much tougher, approach. Immigration is viewed very much not just through an enforcement lens, but also through a national security lens. And when you view things through a national security lens, it leads to certain policy conclusions. And I think you saw that with the executive orders that were issued, right after the president took office. And we were talking about earlier, one of the, maybe domestically, one of the biggest things that I see going forward is, an aggressive, rapid, and really wide-ranging expansion of detention, immigration detention. I think you could expect immigration detention, which is, I think ICE right now has a capacity to detain about 45,000 people, I think, on a given time. You're going to see those numbers go way up over the next, few years, if they get the funding, which I expect that they probably will. Detention is huge because detention really drives so many other things in the system. It moves things faster. It makes counsel more difficult for people. It makes people that have asylum claims, more difficult for them to prepare the claims. So and I think the administration is okay with that. I mean, I think that again the view is that certainly the Obama administration, despite having removed more people than other administrations before that, was lax. That's the view. It was lax on enforcement, and the new administration is going to fix that. So I would expect that you would see a rapid increase in detention. I would you see more immigration courts being housed in detention centers, or being, more judges being, placed in detention centers to adjudicate cases. In terms of more specifics for the immigration courts, I think it's really too early to tell. We really, I didn't really get a sense before I left the department that the department was planning anything big. We'll see. I mean, it's certainly possible that there could be something bigger coming down the pike. I do think that the Attorney General Sessions is very interested in immigration issues. That is one of his things. He's very, very passionate about it. Again, very much with an enforcement lens. But I do think because of that, there could be other changes for the courts coming down the pike. But it's early. We still, it's only been 6 months. So we'll see what the future brings. But I do think that the Attorney General is quite interested in these issues, and we'll see something from him.
Only 6 months. Wow, that's something to consider. Let me. I don't know. I want to give Dora Shriro is here with us today, and she was she led the civil detention reform efforts in the early days of the Obama administration. I don't know if you'd like to say. So I don't mean to put you on the spot, or do you want to? Oh, she's in there. Oh, she's here. Okay. Oh, if you want to say something, Dora, if this jogs your memory, or you want to respond to any of this, or what's going on in the administration, or what didn't happen in the Obama administration, or you don't have to, but I wanted to give you the opportunity to say something if you'd like to.
Sure, why not?
Yep.
Thank you.
You want to come up?
Yeah. I'm very concerned. I agree that we can anticipate an appreciable increase in detention, but referencing our earlier conversation, I'm also concerned that we're going to see an increase in harsher conditions. It fits in the kind of punitive mode, which is contrary to all of the court rulings about the purpose of civil detention, which is exclusively to hold someone when and if they need to be held only for as long as necessary for the sole purpose of making a determination whether or not they are then subject to either removal or relief. And so some of the reforms, but more importantly the qualitative changes that they made in people's lives are likely to roll back. And so you may see more illness, you may see more deaths in detention. There may be some increase in people that you can't account for if just some of the basic record keeping that was put in place is eroded over time. And again, if that's your approach to the detention, then I think it's going to lead in a direction that is troublesome.
Well, and I think that just on that point a little bit, I think one of the reasons why you're seeing the expansion of detention is that it is, and I will tell you this, and this again, this is one of the lessons learned from the border situation a few years ago, was that the only way that you actually guarantee removal is to detain somebody. You know, that is what ICE will tell you, and they believe, and you know, in many cases they're right. I do think that one of the things that DHS did start a couple of years ago that is promising, and I hope that will continue, although I really don't know much whether it will or not, was while it was in fits and starts, there was an effort to try to get an alternatives to detention program that is meaningful, you know, up and going and in place. Again, it was very small. I mean, it was very small. It didn't affect a lot of people, but there was at least a policy recognition made that maybe not everybody needs to be detained. That maybe some folks, while they're awaiting their removal hearings, can be under an alternatives program, whether it's an ankle monitor or whether it's a regular check-in with, you know, organizations or something like that. And while it is still very much, I think, in its infancy, that I think is a more nuanced way of doing detention writ large that may actually be doable. Now, again, I don't know what the plans are for in AWD's Alternatives to Detention Program, ATD program, but it is something that I hope we don't lose sight of.
Okay, questions please, and if you could come up, that would be great. Please come up. Yeah.
Hi. When you were talking about the long delays
And please identify
I'm sorry,
yourself.
my name's Vicki Nielsen. I'm the legal director of Immigrant Justice Corps. You were talking about the long delays in hiring immigration judges. Could you talk a little bit about what that process is? I mean, I know there's security checks, but it's kind of opaque from the outside. And then sort of secondary to that, it seems like such a high percentage of IJs come from an enforcement background, either as trial attorneys or with DOJ, and just maybe you could speak to that as well.
Sure. Thanks, Vicki. It was a process that was put in place several years ago, and it is roughly as follows. Doing a shortcut, but I think you'll understand why. There's an open application process. You put an ad out saying we're looking for immigration judges for these 5 courts. Of course, the last few years we've been looking for immigration judges for every court. So it was really nationwide ads, you know, that would go out on USA Jobs, which is the federal government's, you know, job site, and posted with a lot of other organizations saying we're hiring for immigration judges. A lot of people put applications in. There were a lot of applications put in. I'm trying to remember what the numbers were, but I think in the 2015 ad, I think there was something like 8,000 applications that were put in for like 55 positions or something. It's really quite a large number. Those applications are then vetted for the initial qualifications. You know, the minimum amount of experience. You know, Are they lawyers? I mean, just the basic stuff. And then the agency, EOIR, does the initial cut. And what that means is that they take and evaluate each application, interview a certain number of people, and then select a pool of people to refer to the Department of Justice for further consideration. So and that takes quite a while. I mean, those are applications that are done by senior management judges, and it can take a while to get through that number of applications. Again, for a smaller pool is then selected for further review by the Department of Justice, and then the Department of Justice does its review again, interviews, review of applications, and all that. A final selection is made for each position, recommended to the Attorney General, and the Attorney General makes the final selection for an immigration judge. Now, that's not the end of the process, and when I say the Attorney General, when I mention that the Attorney General is making the selection, that will tell you something significant right there, because it's an Attorney General selection, the next part of the process is extremely important, which is the security clearances. If somebody is selected by a lowly EOIR director, then you're not probably going to have that. But if it's an Attorney General selection, that means that a full security clearance is then done for these positions, especially if they're coming from outside of government, before they can actually be formally appointed by the Attorney General as an immigration judge. So there's a selection by the AG and then an appointment by the AG after the security clearance is done. All of the immigration judges that are still being appointed right now were actually selected by Attorney General Lynch. They were selected under the prior administration. They're just now coming on board as formal appointments by Attorney General Sessions, but that tells you a little bit about how long this process takes. The ones that are coming on board right now, that you've seen some of the news releases on, I'm pretty sure every single one of those judges, while appointed by Attorney General Sessions, were initially selected by Attorney General Lynch, and then gone through the security background clearance. To answer your question, Vicki, about yes, a large number of them do come from ICE and from enforcement agencies. That's two things going on with that. Number one, it does reflect the applicant pool. The largest single number of applicants for that respond to the initial ad are ICE trial attorneys. That is the single biggest pool by far. And that may not be too surprising, because when you think, in the federal courts even, sometimes U.S. attorneys, they kind of move up into the judicial realms. This is kind of the same dynamic. It's kind of viewed as a little bit of a kind of a career step forward, step up to become an immigration judge, and so a lot of them do apply, and that is the single biggest applicant pool. The Obama administration did and I think it's very important to try to get as a diverse, a core of immigration judges as possible, people from within government, different agencies within the government, but also from outside of government. Until recently, though, the background clearances for people coming from outside of government took much longer, are taking much longer than those coming from within the government, for obvious reasons. If you're an attorney within the government right now, you already have to have at least a partial security clearance. You've been vetted. You've been, your bankruptcies were examined and all that. You paid your taxes and all that. Coming from outside of government, that process takes much longer than people coming from within government. So I think you will see a few people, hopefully over the next few months, that have been stuck in the security clearance process that are more. There's more variety. There's more diversity in terms of non-government experience. But you're not going to. But still, for the most part, there are going to be attorneys from within the government that are being appointed. I remember there was one attorney that was appointed from a public interest organization that I did the final interview for in the summer of 2015, and she was just appointed at the end of last year. It took that long to get the security clearance. It's not great, it's actually, as I said, very frustrating when the need is so great to have that kind of process. I do think that the current administration is making some efforts to try to streamline that process a little bit, but we'll see what the effects are. I think that what I fear with the courts right now is just not quite to your question, but that while there are a lot of judges and resources being added, and expected to be added over the next few months and years, we're also seeing a lot more cases coming into the system. We're seeing cases that, again, may have been closed under the prior administration through the exercise of prosecutorial discretion being reopened and being recalendared back in immigration court. What I fear is that even with the new resources being added, we may just be back at square one if the number of cases also is going up, as well as the number of adjudicators. So I think that that's something to watch going forward.
Please come up and ask questions, yeah, and you can line up too.
Hey, Juan.
How are you doing?
Welcome to the other side. My name is Ruthie Epstein. I am interested to hear from you. So Sessions has made it very clear that he wants to ramp up prosecutions for illegal entry and reentry, and has directed his U.S. attorneys to appoint special prosecutors to do so. What do you think that's going to look like? Do you think it's going to be significantly different than what we saw under the Obama administration? Will there be resistance from individual U.S. attorneys' offices, et cetera?
Nice to see you, Ruthie. So that's a great question. I don't know, to be honest. I think that what the Obama administration started to do, what the department under the prior administration started to do, certainly over the last couple of years before the end of the administration, was that most of the U.S. attorney offices along the southwest border did apply somewhat of a more nuanced, approach to prosecutions of illegal entry, illegal reentry. For the most part, with some exceptions, but for the most part, first-time border crossers were not likely to be prosecuted towards the end of the administration for 1325, what they call 1325 prosecutions, misdemeanor prosecutions. Generally speaking, the prosecutions were reserved for, the repeat border crossers, the guys with some criminal history, things like that. Again, with some exceptions, but there was somewhat of a movement towards a more, a nuanced approach, I suppose, recognizing that it may not be the best use of government resources and prosecutorial resources to go after, a first-time border crosser. Certainly on a going to federal court. A lot of the federal judges, frankly, were not crazy about that as well along the southwest border. I do think that is going to change, and I do think that has started to change. I think the message from the new Attorney General is a more of a zero tolerance. I think that's deliberate. I think that's his view that that these are valuable prosecutions that will deter illegal entry. And you will see, I think, some ramping up of that. You may see probably some ICE and CBP attorneys being detailed to U.S. attorney offices to serve as what are called special assistant U.S. attorneys, or SAUSAs, to prosecute these cases, because a lot of these attorney offices really are stretched in terms of the prosecutorial resources. But the way around that is to have DHS attorneys then detailed to those offices to serve as prosecutors. And that's how a lot of this has been done in the past. I would expect that you will see more of that. Again, I do think, however, that there is, it's still an open debate as to how effective those prosecutions are in terms of deterrence. I'm not sure that is, I think the jury is still out on that. I think the data that we saw over the last few years is just really inconclusive on that. I don't know how effective those are. I think if you're talking about prosecutions of repeat border crossers or felons or things like that, then it can be pretty effective. But first-time illegal entries, I'm just not so sure.
Please come up if you have questions.
Hi, Karen Anderson Ponzer. I'm the Director of Legal Services at Neighbors Lane Community Law Practice, north of the city in Westchester. I had two questions, and one related to the last point is I just wanted to get a better sense about how on the ground right to counsel, how people get access to counsel for a criminal charge at the border. I have an idea, but I thought perhaps you have more insight. And then also related to the border, I was wondering if you you have a sense of how immigration court's resources are being utilized for review of credible fear and reasonable fear interviews. I know I have a little stronger sense of credible fear, but especially now, given prosecuting illegal reentries and with requests for a reasonable fear interview, how that may be tapping into court time.
Sure. So on the first point, in many districts along the border, it's the federal public defenders that have a big role in representing people. Remember, these are criminal proceedings, and so you're gonna have a right. You have that pesky right to counsel that we don't have in immigration court always. So you're gonna have appointed. You're gonna have public defenders in the districts. If you don't have enough public defenders, then you have court-appointed lawyers that will come in for the day and represent people in these proceedings. And these are, by the way, I don't know if any of you have been to these court hearings. They're really amazing. I mean, they're in the Tucson courthouse. I mean, you have 60, 70 people a day just coming through these massive court hearings for illegal entry prosecutions, or sometimes illegal entry or illegal re-entry prosecutions. And it's just like this, it's just a massive, it's unlike most federal court here. You see this in immigration court all the time, of course, but in federal courts, it's unusual to see that kind of volume and that kind of pace. So that's how people get lawyers, for those proceedings. I mean, they're basically appointed by the court because and a lot of them are public defenders. In terms of review of credible fear, yes, immigration courts, certainly since 2014, but certainly also lately, have had a big role in the review of credible fear claims. I know that a lot of the courts, in Southern California, in Texas, and in Arizona, is taking up a lot of their time to do these reviews. Now they're fairly quick cases. They're fairly, they're not a regular removal case that takes much longer, but it's still, when you're talking about the number of resources that are available, it is a significant issue. I can't remember what the numbers were, but the administration ordered immigration judges detailed to some of the locations along the border earlier this year, detention centers along the border, and a lot of the cases that they did end up seeing were credible fear cases. Again, the numbers are down lately, so there may not be that many, but there was always a mixed diet of regular removal cases, bond cases, and credible fear cases that most judges in these locations have had to hear.
Does that increase backlogs when they're seconded like that?
Yes.
Significantly.
Sure, and I should probably mention that's while that was obviously the directive to send a number of judges and staff to some of these border locations and detention locations around the country, that had a serious effect on court backlogs and in the courts that they were coming from. If you take, and this is a good example right here in New York, a number of immigration judges from New York were detailed earlier this year to locations in Texas and elsewhere as part of the effort to the border surge, we called it, to try to get more detained cases heard more quickly. And that had a serious effect on the New York caseload. This is the biggest court, the busiest immigration court in the country is right here, and when you take judges from such a busy court in large numbers to these locations, then you're going to have an effect.
I think maybe somebody would know this, but the asylum officer backlogs are 150,000 now too, aren't they, or something like that?
I think they're higher.
Higher? Yeah.
250,000.
Please, additional questions?
Could I just ask one backup question to that?
Yep.
Which is just that I was wondering, just again, thinking specifically of reasonable fear as a possible answer to the charge regarding illegal entry. If I'm re-entering after being deported because I have a fear, there is a process for that. Wondering if you have any knowledge about the interface of how that would work if I'm charged in federal court, but then I may seek a remedy of a reasonable, I request a review.
Unfortunately, I don't have a good sense of that. I know that most of the cases that judges would see are credible fear cases. So There were some reasonable fear cases as well, but just not that many, and I just don't have a good sense of that yet.
Okay, thank you.
Yeah.
Can I ask just something that occurs to me now, which is, are any of the Lynch judges being rejected by Sessions?
I didn't see any.
No.
Hello, I'm Lindsay. I work at Brooklyn Defender Services. I'm a BIA interpretive rep. You mentioned the lack of prosecutorial discretion on the part of TAs. In my experience, it seems like the judges have a lot of discretion, and it seems like the same case could have a very different outcome depending on who the judge is. So, to what extent is that accounted for, or are judges held responsible? And I'm also always curious, when someone is removed and the worst case happens, what you said in court would happen does, are judges informed of that, or how, to what extent do they see the consequences of their bad decisions?
So I think what you're trying to get at there is, with the first part of the question, is the kind of the disparities issue. And that's been an aspect of the adjudicatory system for a while, that you do see some disparities, especially with asylum adjudications. Now, having said that, I do think that you have to allow for some disparity. I mean, I think when you have a system that involves individual claimants making cases, with the number of variances that go into that, the level of the evidence, the quality of counsel, the availability of evidence, things like that, you're going to have some disparities. You're going to have, and it is a discretionary system. There's no question about that. Asylum at the end is discretionary. You're going to have some variances. You're going to have some, judges that will grant asylum, 30% of the time, and others that will grant it 70% of the time, and you have to allow for some of that, unless you're willing to go to a more rigid system where a certain sets of facts fit into certain boxes, and then there are grants, and then some of those are not. I'm not sure that that's a good idea for the system for asylum adjudications, but when you have that much leeway, then you're going to have some variations. Where it starts getting troublesome is when you're talking about wide variations. When you're talking about same type of case in the same same nationality, same court, or even similar courts, and some judges granting asylum 5% of the time and others 90% of the time. Then I think you'd have to start looking at what is going on. I do know that the agency has done a lot of work on that, looking at what is going on with the outliers, with those judges that are kind of on the extremes, and maybe doing some mentoring, some training. Maybe there's a legal deficiency there. Maybe some additional education is necessary, and it has, since the initial studies were done, about 7 or 8 years ago on discrepancies, there has been some movement towards the middle, so that I think is a welcome development. But I do think that one thing that would help, and again, going back to something we talked about earlier, is that in many instances the law is not clear, and I think the law does need to be clarified. Law on social group, the law on credibility, things like that. What are the standards? Gang cases, my goodness, Central American cases that we're seeing right now, a lot of them are raising criminal gang-related asylum claims, and there's very little solid guidance on that out there in the case law. So that accounts for some of the variances, I think, as well. So I do think that the effort to kind of take a look at those judges on the outlying judges, but also some clarity on the law would be very helpful in helping to bring some of those discrepancies, a little bit closer together.
Yes, please.
I'm Maria Bordani. I'm out of the subject, but if I understood correctly, can we attribute or largely understand that the large amount of deportation during Obama's administration can be attributed to the imbalance that you mentioned between the resources of the enforcement and the jurisdiction branches? If this is the case, due to the current situation of the zero tolerance policy and the resources for the IC, can we expect even larger amount of people being deported?
So, I don't know if you can attribute the large number of removals to the discrepancies in terms of, the resource variance. I think it was just, it certainly was an aspect of additional enforcement, at the tail end of the Bush administration and then the beginning of the Obama administration, just because of the increase in enforcement resources. So I think it's more that rather than specifically the discrepancy between that and adjudications. I think it's fair. I think it's fair to say that you probably can expect more removals. I think as of right now, they're about the same. The rate of removals are about the same under the Trump administration as under the Obama administration. But I think certainly with the increase in detention, you're gonna over time. I think it's very likely that you probably will see additional removals. I will say this about the current administration. I think that I think that as other parts of the agenda maybe don't go anywhere right now. I think healthcare, the latest news on healthcare and all that. I think you probably are likely to see additional attention being put on immigration. Immigration is not as complicated for the Trump administration as some of the other issues. I think they have a much, pure view of what needs to be done.
Comprehensive reform.
Yeah, that's right. So it would not shock me, and again, this is one of the issues that the new president, was elected on. I mean, the immigration issue really resonated with his supporters, during the campaign. I think you can probably expect, a refocusing on and a doubling down possibly on immigration in general by the administration for the rest of the year. Now that, again, some of these other parts of the agenda may not be going forward that he's interested in doing. You may see some additional enforcement bills in the Senate or in the Congress, additional work on sanctuary cities and things like that, because politically I think it would work for them.
Why don't we take a couple more questions? If you could just come up. Anybody that wants to ask a question, please line up. Yeah.
Hi, Harold Solis from the Court of Justice Court as well. We talked a lot about the courts.
More than a couple, huh?
We talked a lot about the courts. I was wondering, how do you see the role of the Board of Immigration Appeals in this new administration, and what sort of changes we could see that either could help the system or that you think actually be changed to make our lives a little harder?
So far, I didn't see really any changes at the board from the prior administration. I think the board obviously has an important role. They are part of the review process that ensures that the law is right and the due process is followed. I didn't get any sense that there's any changes going to be happening at the board. It certainly could happen, but again, it's still early, as we keep saying. So I don't really have an answer for you in that regard. I will say this, that the board does offer, a lesson of sorts for kind of the entire removal system, the court adjudicator system, because unlike the immigration courts, the board does not have a backlog. The board is keeping up with its incoming cases. They're doing, good decisions, but they're also able to keep up with the incoming caseload, and their caseload is pretty stable. It's not going up. In fact, it's about the same or even slightly declining. That offers a lesson, because why is that? Because the board does have, that imbalance that existed in the immigration courts with the resources available does not exist at the BIA. They do have enough resources to handle their caseload, and I think you're seeing that that's the effects of that. So I hope that does offer a lesson of sorts for the administration going forward.
My name is Dennis, and I'm from the Institute for Defense Analyses. You had brought up on a couple occasions, you see that there are issues with immigration data and how it's interpreted. I'm wondering if you can please expand on what you mean by that.
Well, I just think that that because each agency has its own mission, they and this is nothing wrong with this. I mean, agencies put together their data systems in order to help them fulfill that mission. That data that is produced is not often the data that you want to try to measure larger things like immigration trends. So, for example, just to give an example, EOIR obviously produces data on the number of orders of removal that are issued by immigration judges every year. You know, X number of removal orders are issued every year. If you take that data and say how many people are actually removed from the country, that's going to be fallacious, because there's, you know, tens of thousands, hundreds of thousands of removal orders right now of people with removal orders that have never been removed. You know, that's just the reality. ICE has just not removed those individuals. So using that removal data to show removals is going to give you a very, very inaccurate answer and conclusion. Tracking actual removals is hard, because, you know, that ICE has to do that. But sometimes there's that imbalance where with removals issued by a judge, whether they issued at the border, whether they issued through this reinstatement or something like that. So again, I think that DHS is, at the end of the prior administration, has tried to really get a handle on that and try to do a more comprehensive group of data points that really will allow for the tracking of some of these larger issues. But I think we're still a long way from that. And again, I think it's just a function of different agencies, different missions, and no single kind of coordinating role for something like that.
Hi, my name is Tony. I'm from Brooklyn Defender Services. I was wondering if you might have an insider's perspective on what kind of impact the lobbying efforts from private prison industries might have on the detention policies that we're seeing, or may see in the future.
Unfortunately, I don't. I mean, I don't. They never talk to me, but which is fine. Obviously, they have a big role, and I think that the Department of Justice, certainly at the end of the prior administration, as you probably know, did make a policy decision that end contracts with private companies for the federal prison system. You know, that decision has been reversed now, and now the new administration is going back to using private companies even for federal prison missions. In the immigration context, I think you're just going to, obviously you're seeing that expand, that, you know, CCA and GEO are expanding, and they will be doing more. My guess is that they have a significant effect, that their lobbying efforts do have a significant effect, but I don't have much insight beyond that.
Hello, my name is Joseph. I'm with the Carnegie Corporation of New York. Thank you so much for being here. I was actually hoping that you could speak a little bit about some perceived tension between immigration enforcement and the courts. I think most recently there was a young man, one up to 4 people who were granted special immigrant juvenile status, and nonetheless I believe that the Department of Homeland Security is trying to process expedited removal. And so I was just wondering what your thoughts are on the tension that I was reading about there.
So I don't know the specific case that you're talking about, but I think that my sense is that I think that the immigration, that ICE and DHS, generally speaking, are going to be, you know, are being more aggressive in terms of removing individuals, even if they may have something like a special immigrant juvenile, you know, process ongoing or something like that. I think that procedures that were put in place under the prior administration to maybe, you know, hold those cases in abeyance or kind of not move them forward, you know, are probably in disfavor now. And again, whether it's right or wrong, it's a policy decision that I think that they're entitled to make. So you may see that, you know, that I suppose that's kind of an aspect of prosecutor discretion. You know, if we can call it. I think that if ICE would forbear, you know, last year on removing somebody because they had a special immigrant juvenile status or process ongoing, the decision now may be, no, actually they don't have status, and so we're going to go ahead and remove them anyway. Again, you may not agree with that, but I think that they certainly have the authority to do it.
Karen Grisey, the last question.
Oh.
You always save the best for last.
That's right.
I was narrowing it down to 2, if we have time for 2.
The last 2 questions.
Karen Grisey from Free Frank in Washington, D.C. One was following up on the point about problem judges, outlier judges. I wanted to ask about outlier courts and what suggestions you might have for people working on policy and direct advocacy on what's the best way to bring to the attention of EOIR and its leadership the problems which are not individual IJ problems, but problems with the culture, the administrator, the systemic issues in particular courts. Because I know you mentioned a bit about asylum being discretionary, which at the end of the day it is, but the denials, at least that I'm familiar with, are generally not denials in the exercise of discretion, but credibility or not a particular social group or didn't meet your burden, so they're on the eligibility and not on the discretionary prong. So that's one. The second one I want to ask is, in the Obama administration and under your leadership in EOIR, it seems that great strides were made towards access to legal information through the LOP program and appointed counsel, or better availability of paid counsel for a variety of disadvantaged groups. And I wanted to see if you could tell us where those programs stood, at least at the time you left government, and what you think the future may portend for those programs going forward.
Sure, Karen. So, taking the last one, I think that the council, so the legal representation programs writ large, I mean, can fall into a couple of categories. Number one are actual council programs that you talked about, and really the groups that were covered by that are people with mental disabilities as well as unaccompanied children. You know, you probably heard of the Justice AmeriCorps program, you know, which was an effort, a small program, but I think an important program. And then some smaller programs as well to represent, you know, unaccompanied kids. I don't know if there's much of a future, frankly, for those programs going forward. The Justice AmeriCorps program, you know, my guess is that will probably, you know, end at some point in the not too distant future. And we'll see what happens with that. The other program for people with mental disabilities may actually continue, partly because that was, you know, in part driven by litigation and a court order. The program itself was a policy initiative, but it was in the context of, you know, larger litigation. So that one may actually have more life. But I do think that, you know, that the view that, and I agree with the view that legal representation is important not just for due process for these vulnerable groups, but also for efficiency, you know, is one that that I'm not sure is shared anymore by folks at the department or the administration, and we'll just see what happens with that. But I would think that those programs are probably not going to, at least for the unaccompanied kids, are probably not going to be as robust or may even end in the not too distant future. The other programs are the legal representation program, the legal orientation programs. I mean, that's a little bit different because that's actually, you know, Congress actually mandated that program, the LOP program, and I think it's very valuable. It has had value not just, again, for due process, but also for efficiency. Generally speaking, the studies are, and I saw Oren Root here earlier, but Oren, you can tell us that, you know, generally studies are that people spend less time in detention if they go through an LOP program that EOIR has administered. I think the LOP is very valuable, and I hope that it continues because, again, I think it is a win-win for everybody. But we'll see what Congress wants to do with that and what the administration's view on that is. You know, and I would count those as somewhat of a, you know, it's funny, Don, you asked earlier what are the kind of the successes and the disappointments, you know, of the prior administration. I think that sometimes they're the same one. I mean, council programs I view as a success. I mean, I think that you know, the prior administration went further along on council and legal representation, legal orientation, you know, programs that I think did have a significant effect and really benefited quite a few people and contributed to the efficiency of the courts. At the same time, I also view it as a disappointment because it could have, you know, we didn't go far enough. You know, there could have been more done, for example, again, with the border crisis, with, you know, we had a problem with the border crisis, for example, with a lot of people not showing up to court hearings. Now, some of that was because they blew off the court hearing, but some of it was because they actually didn't have the information, the adequate information as to what their rights and responsibilities were. And there were proposals made to really kind of enhance that, part of the process at the border to really do a more robust, legal orientation type, programs at the border to try to fix that problem, and that really didn't go anywhere. To me, that was a disappointment. But I do think that those programs are very valuable and and worthwhile at least thinking. I hope the new administration at least looks at some of that and continues a lot of what was done. In terms of the first part of your question, I think that, as I said, you're going to have some variance. I think the focal point has to be due process. And as long as due process is followed in the courts, you're going to have, even though you might have some variances in terms of results, that really has to be what's emphasized. If we really do believe in a court system, and I think we do, then the number one concern has to be that people get their day in court. And the vast majority of judges do that, the vast majority of courts do that. And where it's not happening, I think that emphasizing that part of the process is really where the focal point should be.
Thank you, Juan. After 17 years, everybody's been asking Juan, what his next move will be, and I'm not asking him that, but his stock response has been he wanted a summer without any of this. He wanted it off. He wanted to be left alone.
And then I made the mistake of talking to Don.
So we didn't even let him have his summer off. But I'm very grateful for you, particularly for all your great work over 17 years and for what a terrific public servant you've been, Juan. And thank you for joining us today. And please let us know kind of what your next move will be. I'm sure it will be terrific. So thank you.
Thank you.